The court system. This section covers general information about the federal court system, appeals, useful information regarding filing an appeal, the judges, Rule 60, relief from a judgment or order. There are 3 levels that you might have to face. They are the Bankruptcy Court, the District Court, and the Federal Court of Appeals. For example, you win in Bankruptcy Court, and the judge discharges your student loans. Next, the student loan company appeals this ruling to the District Court. The student loan company knows that for some states, they will win in District Court. In some states, such as Illinois, it is almost impossible to get your loans discharged. Now, the district judge will reverse the bankruptcy judge's ruling, and now your student loans will not be discharged. Do not despair. Next, you will have to appeal to the Federal Court of Appeals. This court might reverse the district court's ruling, reinstate the bankruptcy court's ruling, and now your student loans are discharged. There have been cases where people have lost in bankruptcy court, lost in district court, but have won in the appeals court. That is the real problem. These judges are all over the place when it comes to their rulings. Appeal. If you lose in bankruptcy court, you can file an appeal to the district court. If you lose in district court, then you can file an appeal to the Federal Court of Appeals. We cannot review how to do an appeal because there's just too much information. This would require a few more videos. However, the appeal process is the same at every level. At each level, you will have to file an application to waive fees and file a notice of appeal. You can find these forms on the U.S. Court website. Thus, the only thing we can do is provide the following. The student loan companies know that most people do not know how to do an appeal, and that ones that might figure it out will lose just because they miss deadlines. The deadlines range from 14 days to file the required notice of appeal and 60 days for additional required paperwork. If you miss just one deadline, you will automatically lose. Most people lose because they missed a deadline. In order to start an appeal, you must file a notice of appeal, and this must be filed in 14 days. It is a simple and easy form to fill out. The heading or caption for the notice of appeal is different for each level. Plus, remember that when you mail the notice of appeal, you must create a certificate of service. Please see video 4, Motions, Certificate of Service, and Affidavit, on how to create a certificate of service and the procedure. For the district court, you are appealing from bankruptcy court to the district court. Then for the Federal Court of Appeals, you are appealing from the district court to the Federal Court of Appeals. For each level, you will receive a case number. Thus, you will have a case number for your bankruptcy, a case number for your bankruptcy court, a case number for your district court, and a case number for your Federal Court of Appeals. For each level, you must state all the case numbers on your documents. This is the case number for your bankruptcy. This is the case number for your bankruptcy court. This is the case number for your district court. And a case number for your Federal Court of Appeals. The example we just provided is from a brief, and not from a notice of appeal. We wanted to show the different case numbers for each level. For the notice of appeal, the case number you will use will be from the level you are appealing from. You can go to the U.S. Court website and download a copy of a notice of appeal, Form B417A. Plus, download a document called Federal Rules of Appellate Procedure. Filing a civil case without an attorney. A guide for the pro se litigant. A guide for the pro se litigant is for Illinois, but it has a lot of information that can be used for all the states. The Federal Rules of Appellate Procedure provides all information regarding the federal courts, but without having some background on the federal court system before reading it may make it seem overwhelming. We put a copy of the Notice of Appeal, the Federal Rules of Appellate Procedure, and the Filing a Civil Case Without an Attorney, a guide for the pro se litigant, on our website. Very important, do not miss any deadlines. Most people lose their appeal just because they miss deadlines. We provide a general outline of the appeal process on our website. It is a 7-step process. We did not include the deadlines. Try not to miss a deadline. With the outline, we include the Federal Rules of Appellate Procedure, Rule 28, and Rule 32. Rule 28 tells you what goes into an appellate's brief. Rule 32 provides the federal format for a brief. This includes the color of the cover page of the brief, blue, page limitations, typeface, etc. Federal Rules of Appellate Procedure is different than the Federal Rules of Civil Procedure. Try not to get them confused. Useful information regarding filing an appeal. We provide an example on our website of a general brief and the statement of certificate of compliance. Remember, the Federal Court of Appeals for your area might not be in the same state where you live. Ask the clerk where the Federal Court of Appeals for your state is located. We know that you might not understand the following, but we will add this information now to make sure you have it. For each level of an appeal, you must have a statement of certificate of compliance. This statement goes at the end of your brief. Basically, it states that your brief is less than the maximum number of pages, that you use the correct font, etc. For district court, in the jurisdiction section of your brief, you would reference 11 U.S.C. Section 523 A8, 28 U.S.C. Section 158, and Federal Rule of Bankruptcy Procedure 7052, and 28 U.S.C. Section 1334A and 157A and B. For the Federal Court of Appeal, in the jurisdiction section of your brief, you would reference 11 U.S.C. Section 523 A8, 28 U.S.C. Section 158, and Federal Rule of Bankruptcy Procedure 7052, and 28 U.S.C. Section 1334A and 157A and B. Plus, add Federal Rule of Appellate Procedure Rule 6. If you file an appeal, remember to base your argument on what the bankruptcy court judge stated in his ruling on why you lost. Our best advice is as soon as you file your paperwork in bankruptcy court, try and figure out how to do a federal appeal. Many federal courts have a free lawyer you can talk to about the procedure, but you have to make an appointment. In addition, one can only file bankruptcy every 8 years, and if your situation changes, then you can try again to discharge your student loans. The judges. A lot of it depends on the judge. For example, one woman was married. Both her and her husband worked. They were current on their mortgage, and they had a few kids. She was able to get her student loans discharged. The fact that she had children helped a lot. Another woman was collecting Social Security disability, was receiving food stamps, and worked a part-time job. Her loans were in default. The judge said that there were times where she could have made a token monthly payment. Because of this, her loans were not discharged. Thus, she failed prong 1 and prong 3. The judge was 100% wrong because the Federal Court of Appeals stated the following, according to the ruling in Durrani v. Educational Credit Management Corp., which states, the question, framed by Brunner in this first prong, is whether Durrani can maintain a minimal standard of living if she is required to pay this loan, not whether she has any surplus in her budget available for a monthly payment. Please see case law in Re Durrani v. Educational Credit Management Corp. In Re Durrani 311BR 496 504 Banker ND I11 2004. And Educational Credit Management Corp. v. Durrani 320BR 357 ND I11 2005. Our website has examples of case law that might help. Plus, a few monthly payments would not have stopped her from going into default or have gotten her out of default. You have to watch what these judges state in their rulings. When you do an appeal, if you can, Look up and use as many case laws that support your argument as you can. However, it seems like if you're black or a male of any race, you have a much harder time getting a discharge than someone who is female and Caucasian or white. However, if you are receiving Social Security disability or can prove that you will never be able to work, then all you have to do is file a form with the U.S. Department of Education and your student loans will be automatically discharged after 3 years. We reviewed this in Video 5, Social Security, Student Loans, and Income Repayment Plan. There was an 80-year-old woman who had Alzheimer's that was still paying her student loans, and her family did not know that all they needed to do was submit a 4-page form to the U.S. Department of Education. All the many times her family called the student loan company, they never told them or their lawyer this information. The point is, you never know what a judge is going to do. Rule 60. Relief from a judgment or order. Even if you lost in bankruptcy court, lost in district court, and lost in the Federal Court of Appeals, there might be another way to win in bankruptcy court. You might be able to file a motion for relief from judgment pursuant to Federal Rules of Civil Procedure Rule 60, B2, or B6. In this motion, you are asking the bankruptcy judge to cancel her ruling and provide you with a new trial based on new information. If the judge does, then you might win, and if the judge does not, then nothing changes. You can use this law if your situation changes, such as you are now receiving Social Security disability, you had kids, or a host of other reasons. You can look up Federal Rules of Civil Procedure Rule 60B over the internet for more details. Review Video 4, Motions, Memorandum, Certificate of Service, and Affidavit for procedure on motions.